Okay, so I believe that the first session is with Dr. Khairul, where you guys actually discussing about the Islamic jurisprudence of fiqh Islamic. So now continue with my session, okay, in this second session. So for today, okay, we're gonna look into the history of fiqh stage 2, okay, Sahaba, or to be exact, during the period of Khulafa al-Rashidun, okay. So last week we have actually looked into the, the history, okay, of the Usul al-Fiqh, what happened during the, period of Prophet and Sahaba and Tabi'in and Tabi'in. So today we're going to continue, okay. We're going to look into specific period of Khulafa al-Rashidun, okay. Today we also be dealing with a quite technical topic, which is the method of, deduction, okay, of Usul al-Fiqh. So I will try my best to make it simple, okay, so that all of you can understand it very well. And I believe, here in my participant here, there are those who actually have studied this in depth. Of course, for all of you who actually have studied this previously, it's not that difficult. But for those who doesn't have a Sharia background, then it will, take a little bit of time to understand this topic, inshallah. Okay, so we'll proceed with our next topic, which is history of fiqh in stage 2, Sahaba. Okay, let's see. Bismillah. Okay. So today we're going to look into the problem-solving procedure of the righteous caliph or guided caliph of Khulafa al-Rashidun. So let's see. Okay, good. So what the Khulafa al-Rashidun will actually do when they face issue or problem. So firstly, they will search the ruling or the answer in the Quran. And if let's say they found the answer, they will give fatwa or rule accordingly. That is the first one. And if let's say they didn't find the answer in the Quran, so they will proceed to the next step, which is to search the answer in the Sunnah or the Hadith of Prophet Muhammad sallallahu alaihi wasallam, whether in saying or action, and even the taqrir, affirmation of the Prophet. And they will also actually ask the other Sahaba whether the Prophet ﷺ has given any fatwa or decision on similar incident. Okay, because Sahaba is not with Prophet all the time. Okay, because Sahaba, they have to work, they have to earn their living as well. Okay, so sometimes they will be Prophet, and sometimes they have to go to work. Okay, so they will not know all the Sunnah of Prophet or the Hadith, so they will try to ask the other Sahaba whether or not Prophet has given fatwa on such similar incident. Okay, and if they say they found the answer in Sunnah, then they will make their fatwa, or they will rule accordingly. Okay, and if let's say they cannot find the answer in Sunnah, they will move to the third step, which is they will call meeting of the major Sahaba or the Kibar al-Sahaba, and they try to get consensus of opinion among them to solve the problem. Okay, so this consensus will be referred as Ijma' al-Sahaba. Okay, so yes, especially during the period of Khulafa al-Rashidun, like during the period of Abu Bakr, Umar al-Khattab, most of the Kibar al-Sahaba, the major Sahaba, were still there, still around Medina. So they can simply, call a meeting, and they will do this Ijma' al-Sahaba, okay, when they have any problem. And, if let's say after they make this Ijma' and they found the answer, then they will rule accordingly. But if let's say they cannot actually come into consensus, okay, they cannot arrive into consensus, so they will actually have to proceed to the next step, which is if unanimity couldn't be arrived at, they would then take the position of the majority's opinion. Okay, so here, if let's say they cannot get the ijma, they will resort to the majority's opinion. Okay, then if let's say they can get this majority's opinion, they will rule accordingly. And last but not least, if let's say they still couldn't get the, majority's opinion. They will go to the last step, which is they will make their own ijtihad. Okay, if the differences were so great and there is no majority's opinion, the caliph or the khalifa would make his own ijtihad based on different views that was discussed among the companions. Okay, so these are the steps that the khalifa or khalifa al-Rashidun will actually take where they have any problem. Okay. Sorry. Okay, so this is the summary here. We can see, okay, from Quran, no answer in Quran, they will proceed to Sunnah. No answer in Sunnah, they proceed to the Ijma'. And now, if let's say they cannot find answer in Ijma', they will go to majority's opinion. And if let's say they still cannot find the answer, then they will resort to personal ijtihad or individual ijtihad. Okay. Okay. Next, okay. Okay. In a specific situation, if they were asked a question that needs immediate answer, where the call for ijma' is impossible or near impossible, the Khalifa used to exercise personal ijtihad. Yes, okay. Because when we talk about ijma', then of course they have to call upon the Sahaba to join their meeting, the ijma', and of course to wait for the others to join the ijma', it will actually take some time. Okay. Like us today, if we say we have a meeting, of course, we have to make appointment earlier so that the others can join. So the same thing actually happened here. Of course, when they want to access this ijma', they need, to invite the other Sahaba to join them, and this will require time. So if let's say it is a very urgent case, the Khalifa will actually exercise his personal ijtihad. Okay, and if this happens, well, the Khalifa they actually exercise the personal ijtihad, they will strongly stress out that this is their personal opinion and not the consensus or not the ijma'. Okay, for example, here we have Abu Bakr, okay, radiallahu anh, I used to say the following sayings whenever he exercised individual or personal ijtihad. Abu Bakr will say, this is my opinion. If it is correct, it is from Allah, and if there is any mistake, it is from me, and I ask forgiveness from Allah. Subhanallah. That is me to show the humbleness of the Abu Bakr. Okay. Number two, we have Umar al-Khattab. He also will inform whoever is writing his opinion to quote, this is the opinion of Umar. Okay, in order to differentiate between his personal opinion, his individual ijtihad, and the collective ijtihad or the ijma', okay, of Sahaba. And this is also actually to differentiate between the opinion that he gave on individual capacity as Kibar al-Sahaba, and the opinion that he gave on the capacity as Khalifa. Okay, so this is how the Khulafa al-Rashidun, especially Umar and Abu Bakr and perhaps others as well, this is how they differentiate the opinion of their own personal ijtihad and the opinion of the consensus. Okay, and next, so this is a clear example. Okay. Okay, good. Number one, statement of divorce or talaq. Okay, in order to discourage abuse of divorce, Khalifa Umar altered an aspect of law of divorce through his decree or order. Okay, so this happened during the period of Umar. In the time of the Prophet ﷺ, the pronouncement of 3 divorce statements at one time was considered to be merely one divorce statement, and it was reversible, which means it can be, the husband can perform ruju'. Okay, so this is during the period of Prophet. So if let's say husband pronounced talaq 3 times, okay, I divorce you, okay, so it will be considered as only one talaq, one divorce. But during the period of Umar, Umar declared such multiple pronouncement to be binding and therefore irreversible. Okay, so which means during period of Umar, if they say the husband say talaq 3 times, then it will become 3 talaq, and then it cannot be reversible anymore. Okay, because we only can 3 talaq. Husband can only talaq his wife for 3 times only. Okay. So what is the reason why Umar actually made this kind of decision? Because there was tendency among people during his time to easily divorce their wife. Prompted Caliph Umar took this decision. Okay, the ruling is also imposed in order to discipline, to educate the society, and to create awareness among them on the seriousness of such matter. Yes, so this is, the reason why Umar, makes such fatwa. Okay, because we have hadith where the Prophet says, Prophet Sallallahu Alaihi Wasallam said, ثلاث جدهن جد وحزهن جد, which mean 3 matters, okay, or 3 things, whether undertaken seriously or in jest, okay, which means we just kidding, okay, kidding around, are treated as serious, okay. If let's say we say it seriously, it will be considered a serious matter. And if let's say we consider it just, play around, we just want to, make a joke or kidding around, again, it will be considered as a serious matter as well. So these 3 things are, firstly, nikah, marriage, wa talaq, divorce, and raja, ruju'. So these 3 things, okay, will be considered as serious, whether or not you are serious on, okay. So this is the hadith that talk about this seriousness of the talaq. Okay, next. Okay, number 2. Okay, waging war against those who refuse to pay zakah. Okay, so this actually happened after the Prophet ﷺ has demise. Okay, so during the reign of Abu Bakr, some Muslims refused to pay zakah. Okay, claiming that it shall only be paid to the Prophet ﷺ. Yes, okay, among them are the Musailamatul Kadhab. Okay, so they said we only obligated to pay zakat to the Prophet only. Okay, when Prophet has passed away or has demise, then the zakat is no longer compulsory upon us. So this is what they actually say. Okay, so Abu Bakr decided to wage war upon them and said in his famous statement, "I will wage war against those who differentiate between the obligation of prayer and zakah as it is the obligation in one's property." So here we can see that Abu Bakr said he will actually wage war those who try to differentiate between this, obligation, whether it is prayer, zakah, fasting, even performing Hajj, for example. Okay, so this is another example of ijtihad by the Khulafa ar-Rashidun. Next, number 3. Okay, again, this happened actually during the reign or period of Umar. So yes, Umar is among the the most creative and innovative Khalifa. So because during his period, there's happened a lot of new things happen, new development, new expansion of territory, new lot of things happen. So Umar, what happened is that, this suspension of had penalty for theft cases. So Umar al-Khattab suspended the implementation of had punishment for a certain period during the time when Medina was experiencing drought season and there was shortage of food. Okay. The thing is that what happened usually when someone was caught for stealing, then the punishment will be amputation of hand, correct? Okay, we have to cut off the hand. But what happened during this period was there was drought season and there was shortage of food. Okay, so you can see that the reason being that had the punishment can only be implemented if the crime was committed under normal circumstances. And the fact that there was shortage of food during the time was evident that such crime was committed by those who were desperate for food. And this situation falls under the ruling of darurah, or necessity, that permits the forbidden action to be committed. Okay, so basically, what it says here is that during that time, people who actually committed the crime is actually stealing is out of necessity, out of darurah. Okay, otherwise they will actually die of hunger or starvation. So they not actually want to steal the property or food. I mean, internationally without any, urgent need, but they still, because they have to still in order to stay alive. Okay, and because of this reason, Omar suspended the implementation of had punishment or hudud for, I mean, temporarily. Okay, and there is also, a hadith which says that hudud is elevated with uncertainties. Yes, and hudud tudra'u bishubahat, which mean the hudud will be elevated, will be suspended if, let's say, there are uncertainties in that matter. Because it is not easy for us to actually implement or execute hudud. Okay, it is not simply when someone steals, we can simply implement this, and not that easy. There are a lot of shurut or conditions that must be fulfilled. Okay, if, let's say, this shurut or condition is not fulfilled, then we cannot implement hudud. Okay, next. Good. Difference of views among the companion or Sahaba. There are instances where the companion debated and differed the opinion on various points of law in the process of resolving the issues of fiqh. Okay. However, their differences are minor and rarely reach the level of disunity and factionalism as can be observed in the later period. Yes. Okay. So again, differences of opinion is actually normal. It is actually nature and natural. Okay, because we are from different background, we have different upbringing. Okay, we actually go to different school, we coming from different families, so we actually have different perception. We look into things differently. So this actually differences actually bound to happen sooner or later. Okay, so that's why when we have differences among the Muslim, especially related to this fiqh or usul al-fiqh, then we have to respect the other's opinion. Okay, we cannot say that only I actually who follow Quran and Sunnah and not the others. It is not correct. Okay, we have to respect others' opinion. Okay, so let's say here this was mainly due to a practice of shura in arriving to the consensus of opinion, followed by the righteous caliph. Okay, so this is the first one. B, also the attitude of individual companion, individual Sahaba who are generally refuse to make legal rulings, but instead redirecting complicated questions to other Sahaba who are better qualified to answer them. Okay, so you can see even during the period of Sahaba. Of course, Sahaba we have, the general is that the qaida is that all Sahaba is salih, pious, but not all Sahaba is scholars. Of course, there are some Sahaba can make ijtihad, can give fatwa, but not all of them can do so. Okay, so even among Sahaba. When the question is quite complicated, so they will actually redirect the question to other Sahaba who are actually more qualified than them. Okay, so that's how they being amanah to the ilm. Okay, but today, sadly, even those who actually can, they don't have proper training in Sharia. They never learn usul fiqh. Okay, they never learn hadith. They can simply Google, they ask the Sheikh Google and they can simply give fatwa to the public, which is very, very dangerous. Okay? Okay. Okay. Sorry. So this is the example here that I put here, the cartoon here, the comic. Okay, so there's basically two persons who are looking into the same thing and they have different answer. On the left, you said this is 6, number 6, but the other one, the opposite side, said this is 9, not 6. You can see how we can look into the same thing, but we have different perception, different opinion. Okay, so you can see that. Okay, this is just because you are right doesn't mean I'm wrong. You just haven't seen life from my side. No, you can haven't considered my angle. perspective. Okay, so this is to show that we can have different opinion, and it is actually not wrong to have different opinion in Islam. Okay. So main reason for differences of opinion among the Sahaba, let's say, okay. Number one, difference in their knowledge of the existence of particular hadith of Prophet ﷺ in that particular issues of fiqh. Okay, okay. So like I mentioned to you just now, yes, Sahaba, I mean, they have to earn living as well. So sometimes, perhaps for example, like Umar or Abu Bakr, they will follow the Prophet. They will attend the, Majlis al-Alim, the Prophet during morning, but in the evening they have to go. They have to go to work, so they will not know about the hadith that was spoken by Prophet in the evening unless other Sahaba actually told them about that hadith. Understand? So this is again the reason why the differences of opinion actually happen. Firstly, difference in knowledge about the listen of particular hadith. Example here, the view of Sayyidina Ali and Ibn Abbas, who have the opinion that waiting period, iddah period for a woman whose husband had passed away was 1 year. Actually, they were not aware of the hadith as-Sabi'ah al-Islamiyah, which said the Prophet said, Prophet informed Sabi'ah that her waiting was over after the delivery or after giving birth. This is the example. Number two, difference in the acceptance of hadith. Okay, example, refusal of Sayyidina Umar al-Khattab to accept to the claim of Fatima bint Qais that the Prophet didn't rule for her right of maintenance during the iddah period after she was divorced. So Umar here relied on the verse of Surah Al-Talaq, verse number 1. Okay, it's okay. So basically, what happened in this hadith was Fatima bint Qais, okay, one of the Sahabiyah. Actually, she was divorced for multiple times. Okay, or in this case, actually for the third times. Okay, so when she was divorced, okay, so they're living not living under one roof. They're living separately. So the husband, as usual, will actually send the maintenance, give some food, clothing, money, or whatever, to the Fatima bint Qais. Okay, but here what happened was that Fatima actually dissatisfied with the food or money given to her by the ex-husband. So he reported this matter to the Prophet. Okay, where he dissatisfied with what has been given by the ex-husband. So according to Fatima, Prophet said to her that he is not entitled for the maintenance or for any money or for accommodation, even for the clothes. Okay. And the reason why, according to scholars, why Fatima is not entitled to this maintenance after being divorced, because she has been divorced for like 3 times already. So basically, her talaq was final. There is no more rujuk. But for those who are actually being divorced like once or twice, then they will feel entitled for the maintenance of the accommodation and whatnot. But here, according to some scholars, Fatima has been divorced 3 times already, so she is not entitled to the maintenance by the husband. So when she told this hadith, to others, and this hadith actually caught the attention of Umar al-Khattab refused to accept this hadith. Okay, so you can see here, Umar said the hadith narrated by Fatima is actually cannot be accepted. Because perhaps Fatima actually forgot about the hadith and whatnot. So Umar said he will rely only on the verse of Surah Al-Talaq, where Allah said, if let's say, when husband divorced wife, so they have to give to the wife, the proper accommodation, the food, the shelter, and whatnot. Okay, so again, this is the reason why Sahaba has different views among them. Next, number 3, Difference in the interpretation and understanding of Quranic texts. Okay, example here, the very famous one. We have this verse, المطلقات يتربصن بأنفسهن ثلاثة قروء. Okay, so the divorced woman should keep themselves in waiting for 3 courses. Okay, 3 courses. ثلاثة قروء. And of course, the word quru here, this is the I mean, محل النزاع, or محل الخلاف بين العلماء among the scholars. This is where the scholars actually have different views. What is the meaning of quru? Okay, so here we have two groups. The one group say this is quru mean the actual menses. Okay, the actual menses, which is the hayd. And the other group say quru means the period of purity after menses. Okay, so you can see here again, Sahaba can actually have different views of because of the interpretation and understanding of the Quranic text. And number 4, different in method of ijtihad and issues not mentioned. Okay, yes. Now, basically, of course, I mean, when it comes to the issues that actually not happening, don't exist during a period of Prophet, of course, the Sahaba has to come up with new answer, and this answer will be derived from different method of ijtihad, whether it's qiyas, whether it is istihsan or istisna, anyone. Okay. Okay. So again, yes, this is the reason for the differences of opinion between Sahaba. And if you're mistaken, Sheikh Ali Jum'ah, okay, the ex-mufti of Misr, said, actually Allah wants us to actually have different opinion. Why? According to him, said, why Allah? Because in Quran, there are words that actually have different meaning. Like the word quru here that I just read just now. Why Allah purposely or intentionally use this word? Because there are other words that actually will only have one meaning, but Allah doesn't use that word, but use this word. Allah used the word that actually have different meanings. So these actually in narration, Allah actually want us actually to have different opinion, because of these differences of opinion, is actually rahmah, blessing to us as a Muslim. Okay, next example here. Number 1, marriage and iddah. Okay, whether a woman can marry when she is in her iddah period. So Umar al-Khattab held the view that women who enters into marriage contract while she is still in her waiting period, the iddah period, should be separated. Okay, from the man, and it is forbidden for the man to remarry her even when her waiting period has come an end. Okay, so this is the opinion of Umar. Of course, Umar is quite a strict, person. So, and I believe that when she said, she issued that the man is forbidden to remarry this woman, even when the leprous has an actually to give lesson to this man. But according to Ali bin Abi Talib, okay, he's actually have different views, okay, compared to Omar, where Ali doesn't see any reason to forbid the man from marrying the woman or remarrying the woman after once the flood is over. So here we can see we have two different opinions between Ali and Umar al-Khattab. Okay, number 2. Okay, good. Distribution of confiscated land. When Iraq was conquered by Muslim army, the companion differ with regard to the distribution of the agricultural land confiscated from the enemy. So yes, when Muslim army, they expanded the territory, they conquered many new land. So they actually differ, in views in how to distribute the land. So Bilal bin Rabah, Abdul Rahman bin Auf, Yasir bin Ammar, and some of the scholars, opine that the land should be distributed according to the formula stated in the verse. Okay, this is the verse. I know that out of all the booty, okay, ghanimah that you may acquire in war, fifth share, okay, 1/5 of fifth share is assigned to Allah, and fifth also share is assigned to the messenger, to the prophet, and to near relative, orphans, and the needy, and the wayfarer. So this is the opinion of this first group of Sahaba. However, we have another group which include Umar, Uthman, Ali, Muadh bin Jabal. This is among the Kibar of Sahaba. Okay, in some other views, the land shall remain with the owners of the land. Okay, with the owner, but this owner will be requested to pay tax, jizya, for that particular land, and this tax money will be used for the interest of Muslim, to the public. So here again, we have two different opinions between Sahaba. Okay, Q&A. I think that's it. Okay, I think this is very simple. We'll stop here for this. I need to continue to the next topic. Okay. Okay. So the second topic will be quite, technical. Okay. Wait. Sharing screen. This one. Share. Okay, this one. Methodologies of approach noting of Usul al-Fiqh. Okay, let me summarize it first. Okay, good. So this is the next topic, which is quite technical. So methodologies approach in noting of Usul al-Fiqh. Let's see. So we have this in the outline: introduction, deductive approach, inductive, and combination between these two approaches. Okay, let's see. We're gonna dive straight away. Okay. Okay. So, okay. So basically, before this, we have, many madhab. Okay. Like here, we have, the most, more the famous one, we have Abu Hanifa, Hanafi madhab. Okay. We have Malik ibn Anas, madhab Maliki. We have Imam Muhammad ibn Shafi'i. We have Shafi'i madhab. We have Imam Ahmad ibn Hanbal, Hanbali madhab. Okay. And we also have, Imam Auza'i, Tabari, and there are a couple other madhab actually cease to exist because they have no followers. Okay, it's okay. So the scholar of these schools adopted two different approaches to study of Usul al-Fiqh. So basically, we have two approaches. Firstly is deductive. Number two is inductive. So we're gonna discuss these two approaches. Okay, let's see. So this is the summary actually. Yeah. Good. The first one, deductive. Okay, you can see up there. Deductive reasoning works from the more general to the more specific. So we have the general and we have the specific. So it is known as top-down approach. Okay, from top to down. Basically, we have theory, then followed by observation, then followed by testing of the hypothesis. Okay, with specific data of the original theories. So this is the principle here. Basically, you can see in the in the right side. Basically, we have this theories of Usul al-Fiqh. We have the general principle of Usul al-Fiqh, and we apply this principle to the issues or to the specific cases. So this is the basically the brief explanation of deductive approach. We have theory of Usul al-Fiqh, and we apply it to issues or specific cases. That's it. Number two, we have inductive approach. Basically, the specific observation to broader generalization and theories. Sorry. Okay. This it is also called as bottom up approach, from bottom to up. Okay. Observation. Basically, we observe. We have observation, followed by hypothesis, and followed by conclusion. Basically, for this number two approach, basically we have issues. We have specific case. We studied these issues, and after we studied these issues, we deduce the principle from these cases, and now we have the theories. We have the principle, and we're going to use this principle and apply it to another new cases. So this is the differences basically. Okay. So this now deductive, basically we have principle, and we apply it to the cases. But in inductive, we have cases, we study it, and we deduce the principle, and now we have the principle, and we will use this principle and apply it to another new cases. Okay, very simple. Okay, this one I will skip this one. Just the same thing actually, because I want to save time. Okay, so this is important. So you can see deductive approach. Okay, so we'll see in depth here. Oh, sorry. Okay, so deductive approach. Okay, first, deductive approach is to study of sulfate is adopted by Shafi'is and Mutakallimun, the scholar of Ilm al-Kalam, the Mu'tazilah. Mu'tazilis. Jurists from both Malikiyah and Hanbaliya also adopted this approach. Okay, basically this is the approach that being adopted by majority of scholars. Okay, Jumhur al-Fuqaha. It is known as Tariqah Shafi'iyah or Tariqah Mutakallimin or Tariqah Jumhur. Shafi'i was mainly concerned with establishing the theoretical principle of Usul al-Fiqh without necessarily attempting to apply this, principle to, cases, to various forms of fiqh itself. Okay, so as a methodologist, Imam Shafi'i enacted, a lot of, standard criteria, a lot of principle, okay, which to be followed in detailed formulation of the rule of fiqh. But, sometimes it can be applied. He will apply to certain cases, sometimes he will not apply to specific cases. His theoretical exposition of Usul al-Fiqh, in other words, didn't take into consideration the practical application in the area of furu', in the area of specific cases. Okay, so this is brief summary of Tariqah Shafi'iyah. Okay, so here we have, okay, let's see. Okay, so here we have general principle. Imam Shafi'i will create new rule, new principle, and this rule will be applied to specific cases, later. Okay, let's see. Good. Okay, so this is the example. So now we have the principle here. Okay, see on your left, al-amru yadullu ala al-wujub. Okay, al-amr, command actually indicate obligation. Okay, command indicate obligation. Okay, so this is the principle. Just an example. Okay, al-amr yadullu ala al-wujub. Okay, so we can use this principle and apply it to the cases or specific cases, specific issues. Here we have three issues. Okay, for example, we have the first verse regarding salah, for example. Aqimu salah wa atu zakah. This is a very famous verse about salah and zakah. Okay, aqimu salah wa atu zakah, meaning perform salah and pay zakah or give zakah. So we just take the first part, aqimu salah. So when the usulis, the scholar of Usul al-Fiqh, when they read this verse, aqimu salah, so they will know that, okay, so this, aqimu is actually the word of command. Okay, it is, fa'al al-amr. Okay, and we have the principle, which is al-amr yadullu ala al-wujub. The command indicate obligation. So when they read this, they will say, okay, so command indicate obligation. So from this verse, they can understand that aqimu salah, I mean, the performing salah is obligated. So it's actually compulsory upon Muslim. Can you see it? How they use principle and apply it to the cases? Okay, this is salah. Number two, the same verse, but we're gonna look into the second part, which is atul zakah. Okay, perform salah and pay zakah or give zakah. So again, when the scholar of Usul al-Fiqh, they read this verse, they're going to look into the word of atu. Okay, atu means, pay or give. And this atu words actually is fa'al al-amr, a word of command. Of course, there is awal jama'ah, meaning that it was, this verse was addressed to the Muslim at large. Okay, but the thing here, it is word of amr, fa'al al-amr. So again, al-amr yadullu ala al-wujub. Command indicate obligation. So from here, the scholar of Usul al-Fiqh will know that, okay, so the act of paying zakah is actually wajib or compulsory upon Muslim. Okay, can you see that? Okay, and number three, if another example, يا أيها الذين آمنوا إذا قمتم إلى الصلاة فاغسلوا وجوهكم. Okay, meaning, or you who believe, when you want to perform salah, فَاغْسِلُوا وُجُوهَكُمْ, wash your face. Okay, your face. Okay, so here again, the word here is اغسلوا. Again, اغسلوا is فعل الأمر. Okay, of course, again, we have our jama'ah there. It is addressed to Muslim at large. So, اغسلوا. So, okay, when the scholars of Usul al-Fiqh read this verse, they will know, okay, so this is word of amr, this is a word of command, and again, command indicate obligatory or obligation. So they understand from this verse that if let's say we want to perform salah, then we have to wash our faces. Of course, it's followed by hand, head, and whatever after that. Okay, so this is how these scholars of Mutakallimin, they use this principle and apply it to the specific cases. Okay, let's say another example. Okay, so I will only touch the last one, the last example here, because here we can see how the obligation actually changed from wajib to mandub, to recommended. You can see the number 4, that. Okay, we also have the same principle here. Al-amru yadullu ala al-wujub. Okay, we have the verse there. يا أيها الذين آمنوا إذا تداينتم بدين إلى أجل مسمى فاكتبوه. Okay, or you who believe, when you want to actually borrow money, want to make a debt to a certain period of time, you have to write it down, jot it down. Okay, so this is the verse. Of course, here we have the word uktubu. Okay, again, uktubu is فعل الأمر, and al-amr يدل على الوجوب. Okay, this word of command indicate obligation. Okay, so of course, if let's say we only read this verse, we will say that, okay, so if let's say we borrow money from others, we have to write it down so that we will not forget. Okay, so this is the initial rule or hukum. But later the scholars actually found another ayah. They actually changed the hukum from wajib to mandub. What is the ayah? This is, we can see the number 2. Ayah number 2 said, فَكَاتِبُهُمْ إِنْ عَلِمْتُمْ فِيهِمْ خَيْرًا. So Allah said, so write it down. If let's say writing down the that is, I mean, there is benefit to you. That is the first one. And we have number 2. Allah said, فَلَيْسَ عَلَيْكُمْ جُنَاحٌ أَلَّا تَكْتُبُوهَا. Allah said, it's actually okay for you not to write it down, and to not write it down your debt. Let's say you can remember it correctly. So here, even though initially, based on the first verse, Allah said it is wajib for us to write down our debt so that we will not forget. But later, in a later verse, Allah said it is okay if let's say we can remember it. So here, even though initially it is wajib for us to write it down our debt, but later, because of the second and third ayah, the hukum from wajib is changed to mandub, which is recommended. So now it is recommended for us to write down our debt. So not wajib anymore, mandub only. Okay, good. Okay, so this is the explanation. Shafi arrived at this principle by observing the following methods. Okay. So first we have theory. Command is form of request. Hypothesis, deduction, the lawgiver means okay, wajib, binding. Confirmation, any commands from lawgiver renders obligation. The same thing what I have explained just now. Skip next slide. Okay, now we come to the wait, not yet. Okay. In addition, Shafi'is and Mutakallimun are inclined to engage in complex theological and philosophical issues, which may or may not contribute to the development of the practical rule of Usul al-Fiqh. Okay, so such remote relevance to practical rule of fiqh tend to feature more prominently in the work of Shafi'is and Mutakallimin than those of Hanafis. Okay, example here of the theological issues like Islam of Prophet prior to the property of prophetic mission. Okay, basically the sacredness, infallibility of Prophet before they being appointed as Prophet. Whether or not Prophet is ma'soom before they becoming Prophet. This is the example of the issues. Or status of individual or status prior to revelation of Sharia. Let's say, people actually has not received any, revelation. Okay, what is the hukam for their conduct or for their action, whether they will be rewarded or whether they will be punished if, let's say, they haven't received the revelation from Allah subhanahu wa ta'ala. Okay, the logical and linguistic matters. Okay, we'll skip this one. Okay, conclusion. Okay, principle or general rules determine the hukam of branches of fiqh, exception by applying this method. There are a lot of exceptions from legal cases from original principle. So this method is widely used by a majority of jurists because it does not subject to any skill of it. Okay, simple. Okay, inductive approach, I will try to finish it in like 5 or 10 minutes. Okay, because we are running out of time. Okay, inductive approach is mainly attributed to Hanafi jurists. Okay, because it was known as Usul Hanafi or Tariqah Hanafiyah, or Tariqah Fuqaha. Hanafis attempted to expand principle of Usul al-Fiqh in conjunction with the fiqh itself, and tend to be more pragmatic, okay, practical in their approach to this subject. The inductive approach attempts to relate Usul al-Fiqh more closely to the detailed issue, to the furu' fiqh. They will study the issues specifically. Okay. So here is the outline here. Basically, according to Hanafiya or Hanafis scholars, so we have this specific rule, we have these specific cases, specific issues, and from these issues, we will derive the ruling or the principle. Let's see the example here. Okay. Okay. Firstly, we have the verse, وَالسَّارِقُ وَالسَّارِقَةُ فَاقْطَعُوا أَيْدِيَهُمَا. Okay. So here about the amputation of hand of the sariqah or sariq or sariqah, the thief, male thief or female thieves. So Allah said, anyone who actually caught for stealing, we have to cut off their hand. Number 2, verse of Li'an, وَالَّذِينَ يَرْمُونَ الْمُحْصَنَاتِ ثُمَّ لَمْ يَأْتُوا بِأَرْبَعَةِ شُهَدَاءَ فَاجْلِدُوهُمْ 80 جلدة. Anyone who actually accused others, okay, for committing, zina, and they do not come out with four witnesses, أربعة شهداء. So they will be punished with 80 جلدة. I mean 80 lashes. Okay. Number 3, والذين يظاهرون من نسائهم ثم يعودون لما قالوا فتحرير رقبة من قبل يتمسوا. For those who actually perform zihar to their wife, okay, so before they can actually, what we call is, consume their marriage, they have to free female slave. Okay, let's see. So this is the specific verse here. Oh, sorry. Subhanallah. Yeah. So we have the from these cases, scholars of Hanafis actually concluded that al-ibrah bi umum al-lafaz la bi khusus al-sabab. Okay, consideration is actually related to the generality of the wording. Okay, consideration is given to the generality of wording of Quran or Hadith, and not because of the specific cause of revelation. So they will focus on the general word, general term, rather than the specific cause of revelation that lead to that particular issues or case. Okay, let's see. Okay, this is the first one. Okay, the same verse is now imputation of hand for thief is derived from this verse. Okay, again, sariq wa sariqatu faqta'u aydiyahuma. So, okay, what is the sabab nuzul? What is the cause for revelation? This verse was revealed on man who stole garment of Safwan, which was located beneath his head while he was sleeping in the mosque. So, Prophet amputated the thief's hand. This is the first verse. Okay, so this is the verse, and this is the cause of revelation. The sabab nuzul. Number 2. Okay, number 2.
Doctor.
Yes.
We have already finished.
Finish with IIT. Can we send like 5 or 10 more minutes, or we don't have any time?
Okay, because we already passed 10 minutes. You can take 2 minutes to complete it.
I see. Okay, it's okay. So let me try to finish the one in 2 minutes, inshallah. So then we have the verse. Verse of qadha. Okay, those who accuse others without coming out with witness, they will be punished. Okay, sabab nuzul here is this verse was revealed on Hilal bin Umayyah, who accused his wife without producing 4 witnesses. Then number 3, okay, it's okay. This one we skip this part. Okay, zihar, saying of husband to his wife, you are to me like back of my mother, which is unlawful for me to approach. Okay, so this is a kafara of this. I mean, deed is freeing slave. Okay, you know, if let's say he don't have money, he has to fast consecutively, 2 months consecutively. If let's say he cannot do so, he must feed 6 people. That's it. Okay, it's okay. So this verse was revealed on Huaylah and her husband, Aus bin Samit. Okay, so okay, here this is the conclusion here. All ruling in this verse expressed in general term. Okay, because we can see all of us is actually talking about general people. Okay, Sariq or Sadiqa, who are they? It is general term. Okay, again, just now, I mean, wait. This okay. Waladin yarmun al-musana is again a general term. We doesn't know who is the person who committed unless we study the sabab nuzul. So the word use is very general, right? Okay, so wait, okay. Thus, all the ruling in this verse was expressed in general term, not specified no harm, even though they were revealed on specific occasion. Okay, thus, although they were revealed on specific occasion, companion and successors and those who came after them have applied this ahkam, this ruling to all Muslims. Okay, based on this phenomenon, Hanafi jurists formulated principle al-ibrah bi umum al-lafaz la bi khusus al-sabab. So what should be taken into account is general term, not specific occasion. That's it. Okay. So that's it for, you know, deductive approach. Okay, so this is the books on these approaches. Okay, you can read on your own later. Again, this is the book of deductive approach. Well, you can read on your own later, just the title of the book. Next, deductive approach, again, literature, again, the book of deductive approach. Again, you have various books here by, I know, Abul Hasan al-Tarqi, Bazdawi, and so on. Then again, the books of inductive approach, and lastly we have combination of 2 approach. Basically, is when the scholars they try to combine these 2 approach, inductive and deductive approach. Okay, I will not explain again, so you can read on your own later. Okay. Okay, I think that's it from me. This is the book of the combined approach. Okay, I think that's it from me. Okay, thank you for your concentration and for your times. So if let's say you have any question, you can ask me in the chat box and we'll try to answer it inshallah in next week. Okay, I think that's all from me. Thank you so much, everyone. Assalamu alaikum wa rahmatullahi wa barakatuh.